Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, early this morning, being a West Coast guy, my early mornings come later than yours do. Phone started buzzing right away. I'm getting all kinds of messages from people inside our little 2A sphere saying, oh my God, the Supreme Court has accepted a Second Amendment case. Can you believe that? That's right. It came out on a miscellaneous order, which we'll talk about in a moment. But this is a big case, and this is a big deal that the Supreme Court has decided to take this. So today, what we're going to do is we're going to break it all down so you can understand what's at stake. So let's spend a few minutes today and let's talk about the Supreme Court accepts a gun case. Okay, America, for this case, we're actually going to head all the way out to Hawaii. And since we're talking about Hawaii, we know we are talking about an absolutely insane gun law. The case that we're talking about today is the matter of Wolford v. Lopez. We have talked about that case on numerous occasions. Now, we also talked about the fact that there was a pending petition before the United States Supreme Court. Normally, we get the orders list on Monday mornings, okay? And if you go back to the time when we were waiting for Snope v. Brown in the Ocean State case, we were up every Monday morning checking the orders list. But throughout the week, there's also what's called miscellaneous orders, and it can be all sorts of different things that come out on the miscellaneous orders. Well, today, Friday, we got a very short miscellaneous orders list, but lo and behold, right in the middle of it, it says the following. Wolford v. Lopez. The petition for writ of certiorari is granted limited to question 1 presented in the petition. Okay, now for those of you who don't recall, this case is a challenge to a litany of all new sensitive places that the Hawaii State Legislature passed. It was consolidated with also the sensitive places that came out of California Senate Bill 2, got to the Ninth Circuit, and of course the Ninth Circuit screwed it all up. Of the many, many areas that Hawaii restricted firearm possession, the one that we're going to be focusing on today is privately owned property which is held open to the public. Because the way it works in Hawaii is that it is presumed to be a gun-free zone. All private property, even that's held open to the public, is presumed to be a gun-free zone unless the property owner gives you express permission. So when we go back and we look at the original petition, what was the first issue presented? Whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. This is sometimes called the vampire rule because the default rule is that all places in public are open to lawful public carry unless the property owner actually expresses otherwise. But Hawaii actually reversed it or turned it upside down, where it is presumed to be a gun-free zone or a sensitive place unless the property owner gives express permission to that particular person. Now, New York had passed a very similar law, and the Second Circuit had actually struck that law down, which is why in direct conflict with the Second Circuit is referenced in the issue presented. But the Ninth Circuit, shockingly, had no problem upholding it. How did they do that? Well, they did it this way. From the original order of the Ninth Circuit, which is now the subject of this appeal, the court ruled in both the Hawaii case and the California case, the district courts held that plaintiffs are likely to succeed on their challenges to the respective bans on the carry of firearms on private property held open to the public unless the owner or operator consents. Although the state statutes are similar, they differ in one key aspect. Hawaii's law allows a property owner to consent orally, in writing, or by posting appropriate signage on site. California's law, by contrast, allows a property owner to consent only by clearly and conspicuously posting a sign at the entrance of the buildings or on the premise indicating that the license holders are permitted to carry firearms on the property. And you sit there and you go, okay, so what's the difference there? I don't know, but to the Ninth Circuit, it obviously was a huge difference. Now, they did determine that this activity was covered by the plain text of the Second Amendment because last time I checked, the right to keep and bear an arm is right there in the text, but ultimately found that there were sufficient historical analogs to justify this. But the sufficient historical analogs was one law from New Jersey in the 1770s and one law from Louisiana post-Reconstruction era. But the Ninth Circuit, never wanting to let the law get in the way of where they want to go, ruled the following. We conclude then that the nation has established a tradition of arranging the default rules that apply specifically to the carrying of firearms onto private property. Collectively, the laws establish that colonies and states freely arrange the relevant default rules. And the 1771 New Jersey law and the 1865 Louisiana law are historical dead ringers. They simply prohibited the carry of firearms on private property without consent. Those laws, enacted shortly before the ratification of the Second Amendment and very shortly before the ratification of the 14th Amendment, were uncontroversial. They are easily analogous to the sensitive places laws mentioned by the Supreme Court, which ultimately led the Ninth Circuit in determining that Hawaii's law would withstand this constitutional scrutiny to rule. Hawaii's modern laws fall well within the historical tradition. The law prohibits the carrying of firearms onto private property unless the owner has posted signs, otherwise has given written consent, or has given oral consent. We therefore conclude that plaintiffs in the Hawaii cases are unlikely to succeed on the merits. That then led to the plaintiffs in this case, now petitioners, to do exactly that, petition to the United States Supreme Court, and the United States Supreme Court has actually accepted review of that matter. Okay, I checked the docket before we got in front of the camera here. I did not see any oral argument dates set yet. As soon as we know that, we will let you know. But this is a big, big deal. We know it is very difficult to get any type of Second Amendment case to the United States Supreme Court. And if ever there was a state that deserves a big-time smackdown from the highest court in the land, it probably would be Hawaii. Okay, the case once again is Wolford v. Lopez. We're going to go ahead and link up the orders list down below. We'll also link up the petition for certiorari as well as the ruling from the Ninth Circuit so you can all geek out on it for yourself. You don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, that information is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Okay, let's remember, like always, all the research we did for today's video was done where? That's right, at GroundNews. Why is that? Well, I like to get treated like an adult, and I bet you do too. And when you have a platform that's going to scour over 50,000 independent news sources and give you a biased distribution breakdown, let you know how the headlines are being manipulated, oh my gosh, it actually allows you to make up your own mind. Check out the blind spot. This will show you stories that are being disproportionately reported by one side of the political spectrum or the other. And right now, you can get every feature that GroundNews has to offer through a Vantage Plan at 40% off. And all you got to do is go to ground.news/Washington or scan this QR code right here. Listen, if you're finally ready to break free from media manipulation, visit my friends today at ground.news/Washington.